Welcome to the Explainer. Today, we're going to do something a little different. We're not just going to read a law. We're going to take it apart piece by piece, like a mechanic taking apart an engine. We are going to deconstruct the really complex legal framework of rape, and we're going to use the law's own words as our blueprint to figure out how this crime is actually defined, prosecuted, and punished.
All right, here's our game plan for today. We're going to start with the absolute basics, the definition. Then we'll get into the physical act, what lawyers call the actus reus, and the mental state, the mens rea. After that, we'll dive into the circumstances that totally change the game, look at the consequences, and wrap up with the specific defenses and exceptions baked right into the law. Let's get into it. So first things first, you got to understand that the law doesn't just paint this crime with one big, broad brushstroke. No. Instead, it builds the entire definition on two main pillars, two really distinct categories of actions that legally make up the crime.
So let's ask the most fundamental question, right? When you strip away all the emotion and the social context, what does a formal legal document like Article 266A actually say? How does it define this incredibly serious crime? What are the actual words on the page?
And here they are, our two pillars. On one side, you have what the law calls carnal knowledge. It's kind of old-timey language, but it's the specific legal phrase for sexual intercourse. And on the other side, you have sexual assault. Now, this is a broader bucket that covers other types of non-consensual sexual penetration, whether it's with an object or another part of the body. These two ideas are the bedrock for everything else we're going to talk about.
Okay, let's move on to the next layer of our blueprint, the actus reus. Now, that's a Latin term that lawyers love to throw around, but all it really means is the guilty act. Simple as that. Think of it as the physical part of the crime. It's not about what someone was thinking, it's about what they physically did. And wow, the law gets incredibly specific here. The blueprint spells out two very distinct physical actions. First, there's the act of sexual intercourse. But, and this is so important, it's only a crime if it's done under a specific set of illegal circumstances that we'll break down in just a minute. Second, there's sexual assault, which is defined with almost surgical precision to cover different kinds of penetration. The law leaves absolutely no room for ambiguity about the physical acts it's prohibiting. And this right here is where it all clicks into place. The law is crystal clear. The physical act itself is not automatically the crime. It transforms into the crime of rape because of these surrounding situations. I like to think of it like baking a cake. Flour by itself is just flour. But when you add the right ingredients and, crucially, you add heat and pressure, in this case, things like force or the victim's age, it becomes something totally different. It becomes a cake. It becomes a crime. So, we have the blueprint of the act, the actus reus. But a blueprint is just a piece of paper, right? It's a static plan. To actually build something, you need an engine to drive the action. In legal speak, that engine is the mens rea, another Latin term for the guilty mind. This is all about what was going on inside the offender's head.
And the single most crucial point is this. The law says the act must be intentional. This wasn't an accident. This wasn't some clumsy mistake. For an act to be considered this crime, the person who did it had to have acted on purpose. The gears in their mind were turning, and they made a conscious choice.
And this is what that legal intent really looks like. See, it's not just about intending to do the physical act. It's the conscious choice to do that act while knowing about the illegal circumstances. The offender chose to use force. They knew the victim was passed out. They knowingly took advantage of the fact that the victim was just a kid. It's that combination, the act, plus the awareness of the circumstances, that creates the guilty mind. All right, let's zoom in on those circumstances, because honestly, they are everything. Think of the physical act as an actor on a stage. The circumstances, that's the lighting, the scenery, the script. They completely change the meaning of what's happening. Without that context, there's no play, there's no crime. So, the first and probably most well-understood circumstance is just plain coercion, using force or threats or intimidation. It's like a chemical that instantly dissolves any possibility of real legal consent. Because in the eyes of the law, consent has to be a free choice, and force makes that absolutely impossible. Here, the law draws a really bright, clear line in the sand. A person who is unconscious or so out of it they're deprived of reason simply cannot consent. It's a legal impossibility. Think of consent like a door that has to be opened willingly. Well, if the person is unconscious, that door is locked and bolted. Any entry is, by definition, a trespass. And this part is so insightful because it shows the law understands that coercion isn't always physical. A huge power imbalance, like the kind a parent, a guardian, or a teacher has, can be just as powerful as a physical threat. This rule acknowledges that when someone in a position of trust abuses that power, they basically poison the well, making a truly free choice impossible for the other person.
And here we have another hard line drawn by the law, 16. Below this age, the law just decides flat out that a person is legally incapable of consenting to sexual intercourse. It doesn't matter what they said, what they did, or what they thought, legally consent is just off the table. It's like a protective shield the law puts around young people, and in these cases, consent isn't even a relevant topic for discussion in court. Okay, so we've put together the whole picture, the act, the intent, and the circumstances. Now, let's talk about the consequences. Think of this as the consequence equation, the formula for punishment that's spelled out in the law, specifically in Article 266-B. And you can see the penalties are laid out with stark clarity. For rape involving carnal knowledge, the sentence is reclusion perpetua. That's a hefty 20 to 40 years. But notice the big difference for sexual assault, which has a lesser penalty of prisión mayor, or 6 to 12 years. The law is very deliberately saying these two acts are not the same level of severity when it comes to punishment. And this is a really important update to keep in mind. It's a great reminder that laws aren't just carved in stone, they change over time. If you look at older versions of these laws, they actually included the death penalty for some of the worst cases of rape, but that was abolished back in 2006. So today, reclusion perpetua is the absolute maximum penalty you can get. Now let's look at the variables that can make that consequence equation even more severe. These are what we call aggravating circumstances. You can think of them like penalty multipliers. If any of these factors are present, like a weapon was used, or the victim became insane, or the offender was a family member, it kicks the crime up to a higher level of seriousness and triggers the maximum possible sentence. All right, we're at the last part of our deconstruction, the nuances. This is where we find the limited legal defenses and some very specific and sometimes pretty surprising exceptions that are written right into the law, in places like Articles 266C and 266D. Okay, so consent, it operates on this really critical legal tightrope. It can be a defense, yes, but it's like a key that only fits one very, very specific lock. The victim has to be of legal age, they have to be conscious, of sound mind, and totally free from any coercion. If any one of those conditions isn't met, and especially if they are under 16, the law just says consent is completely irrelevant. Poof, the defense just vanishes. Now, this is a very unique and, let's be honest, often controversial provision in the law. It's sometimes called the marriage exception. And what it says is that if the offender and the victim later get married, the criminal case can actually be stopped. It's basically a legal off-ramp that can halt the entire prosecution, but only if the marriage itself is valid and legal. And this, right here, shows a huge pivotal shift in legal thinking. For a very long time, there was this expectation that a victim had to prove they physically fought back. This law says, nope, not anymore. While signs of a struggle can be used as evidence, what's also evidence is just proving the victim was unable to consent. The whole focus shifts from did they fight back to the more important question, were they even capable of saying yes? So there you have it. We've taken the entire legal machine apart, looked at every gear and every lever. We have the blueprint. We know the acts, the intent, the circumstances, and the consequences. And understanding these precise legal building blocks is the absolute first step. But it leaves us with one final, much bigger question. How does this carefully designed blueprint actually work in our messy, complicated society and in the human pursuit of something we call justice?